We are recording. Hello and welcome to the Immigration Podcast. This is a podcast where we talk about the latest immigration issues. My name is Rob Ratliff. I'm a former immigration judge and immigration attorney based in Cleveland, Ohio. And with us today are two co-hosts. Go ahead, jump in, somebody.
Sue, you're the veteran. You should go first.
Yeah, you're a veteran too. Susan Hiller. I'm a former
I didn't get that.
DHS
Could you try
Department
again?
of Homeland Security Counsel and an immigration private attorney right now.
Excellent.
I'm so glad to see both of you again. I think I missed an episode, so I feel like I missed a little heartbeat, but I'm Marium Uddin, and as I've said before, former lots of things. Very happy to be in this space with you. I just Googled that we have like 959 more days under this administration, so we have a lot of topics to get through on this very needed podcast.
Yes.
We do, and things are changing so quickly and rapidly, especially even in the last couple of weeks. It's been an amazing, just one thing after another that's came up and changed. And 2 weeks ago, it was all about healthcare fraud and some of the things that were going on there, and now that seems like that's not even on the radar anymore. It's all the new stuff that's come out. So.
Yeah, I don't know how we're keeping pace, but two of the things that I know I flagged, I wanted to talk to you guys about today and see what your thoughts are. One is, of course, and I don't know if you had already covered some of this on the last podcast, but that USCIS policy that's really upending things for temporary people that come with, non-immigrant intent. And so that's affecting everyone, really. I mean, students, our F1s, our H1Bs, I don't understand the full scope of it, and I'm hearing mixed things about whether or not USCIS is actually going to be happy to implement the policy. I understand there's some tension between USCIS and ICE, with ICE taking buckets and buckets of the money and USCIS kind of being blindsided by what this policy was going to mean. But of course, we hear the government saying over and over again, hey, this is just us reverting to the original intent of what was meant. In other words, people that come here on non-immigrant visas should have to go back to their countries of origin, their home countries, to consular process. So I wanted to talk to you guys about whether or not you think that has any real teeth or whether it's just smoke and mirrors. I think there is some litigation in the works already. Not aware of the actual lawsuit or what the posture of it is, but that was one. And then I wanted to talk to you guys about a case that I'm handling out of a couple they're both professors out of Los Angeles. I don't know if you had read up on the Hashimi family, but Issa and Marium are in removal proceedings with their 16-year-old son. They've been transferred to Texas. So we're proceeding on the removal side as well as the habeas. But the reason for their detention is one of these Rubio determinations, so-called Rubio determinations, where a person is deemed a national security threat or, adverse to foreign policy interests. In this specific case, it's because of Issa's relationship to his mom. She was known as Screaming Mary during the 1979 hostage crisis in Iran. So, for this family to be returned to Iran is the equivalent of a death sentence. And I'm not sure what type of justice is going to be brokered in the immigration courts, also known as the president's courts at this point in time. So curious to talk about both of those with you. And as you know, I won't stay on for the duration. So would love to just kind of throw that out and hear your thoughts.
Well, and Susan, you texted earlier about the Rhode Island decision. Did you have a chance to look into that too much?
Well, it's 135 pages, so I've not been able to read all of it, but my understanding from, the gist of going through the summary is that basically they found the new policy with USCIS with regard to adjustment of status and having to answer these 26 additional questions, which is what it is becoming, the way they're trying to implement it, is unlawful. It's unconstitutional. It violates, of course, it violates the Administrative Procedures Act. They did state that. There's been nothing, that comment and write-in period and such forth. If you're going to change the statutes, which again, the way you change statutes is you have Congress actually rewrite the law, not the president dictate what it is. So I am looking forward to reading all 135 pages, but I believe summing it up is, and I have a question for you on this, Rob and Miriam. Basically, the Rhode Island District Court is saying it's illegal, unlawful, unconstitutional, and they have just stated it. And do you believe that USCIS will use that decision and follow it nationwide, or is that just going to be, you think, something where USCIS says, well, if you live in Rhode Island, okay, it applies to you, but not if you live in North Carolina, South Carolina, or Texas?
Do you know if that, because I haven't seen the decision yet, but do you know if that court held it to be a nationwide injunction, or?
Let me just pull up my other screen and
Because I mean, that'll be the first thing the administration does is challenge the nationwide applicability of it.
Why don't, while you're maybe dive into the other, I'm going to look real quick on, because I just sent this decision to another attorney today. And,
so I'm reading, guys, the decision has nationwide effect, meaning USCIS must apply it to all affected pending applications, not just the plaintiffs represented in the lawsuit. And that's from Fragaman. So I think that's probably trustworthy. Okay. But I think that since the federal government, obviously,
nationwide, correct. Yeah, it does say that.
They're going to appeal the decision. So I think the future of these adjudications obviously remains subject to further litigation. But I also am surprised that the district court came up with that decision, because it's not a new policy. I mean, if we're being fair, it's USCIS returning to the original intent of that policy, which was always to require people who are seeking lawful permanent residence to have to go back to their home countries instead of transitioning from a non-immigrant to an immigrant visa without an additional hurdle being thrown up. So I don't know. I'll have to take a look at the decision as well, but I think it's remarkable that the court found or might have deemed it a new policy. It's not new.
You know, and that's one of the things that I find most problematic about immigration law across the board is that that Congress has completely absolved themselves of any responsibility for anything, and Congress has allowed administrations from both sides to
we have a Congress right now,
kick it back and forth. Yeah, that's it. I mean, they do nothing, so it's allowed administrations to just go from one extreme to another and generate rules. One of the things I've always found really a big problem in immigration law is the way the way it works through the court decisions and the settlement agreements and all that, which is completely outside the purview of the public. You know, a lawsuit will get filed, a class action will get filed, then DOJ will step in and they'll come up with some sort of agreement. And now we have a new policy based on, something that was negotiated, usually a nonprofit of some sort, and DOJ, usually in the Ninth Circuit or someplace. But, that process is just so far afield from the way law is supposed to be made that it just creates all these problems, and it creates the problems with the administrations just using politics as a political football back and forth, and the real impact of that is people that are lured here to become, cannon fodder in the industrial machine, or sold some bill of goods that that there's a better life for them here, and maybe there is, but it puts them in a position where they're having to live underground, where they're not able to fully experience an American dream type of situation, and that I think is at the fault of Congress. The administrations are just taking advantage of the politics of it and doing what they can do to, gather votes. So, and the people get stuck in the middle.
I have going back to Miriam's question. I think you had two, and one was the new USCIS policy with counsel processing, which I believe is illegal. I mean, the whole point of adjustment of status was, and all the different applicable parts of it, like military parole in place, for example. I'm having cases where there's pending 485s that are being denied because the military parole in place has not been approved yet. Well, whose fault is that?
Yeah.
Whose fault is that? That's the agency that's sending me a denial. Do your job. I want to say some expletive words, but do your job. If they did their job on time, military parole place pending for a year, and I got to say this real quick on this particular case. This individual, their child, two children in the military, disabled veteran who got hurt defending this country, and also the other veteran child, 82nd degree airborne, in such a high position within that I don't even know if it's Delta Force, Special Forces, but his father stated, I can't tell you where he is right now. This was months and months ago. I can't tell you where he is right now because he's on a special mission. And now he's back here, but he has to come back to see his father placed in removal proceedings. Military parole in place denied. Why? Because he entered this country 20 years ago and he voluntarily had voluntary return, turned around as almost everybody. I used to work for the government. Everybody did this back then. They were turned around by Border Patrol, voluntary return, which is not even voluntary departure, came back the next day. They said that was a flagrant abuse of the immigration laws, denied his PIP, military parole in place, then put him in removal proceedings. And that's another military parole in place thing that just happened recently. And of course, they assigned him what I think is Corey Lewandowski's brother or family member who just became an immigration judge. They gave him that. And I think it should be nationwide televised because I want the country to see what they're doing to a disabled veteran's father, and somebody who's serving actively in the 82nd Airborne in some Delta Force Special Operations Commando Force operations. Just wanted to add that in.
So what are you doing on that case besides, I mean, I think we can all agree that justice in the immigration courts is probably not an attainable outcome in a lot of these cases. That being said, are you reaching out to congresspersons about this? I know you said that we don't have a Senate, but in any case that there might be somebody that you can reach with congressional power to platform this story. What about other advocacy efforts or just getting the story in the media? Because I think that when we take these cases on, we're signing up to not just represent someone in immigration court, understanding that we're not winning there. So there has to be a multi-pronged approach, and I'm finding that a lot of it to be with advocacy and media and congressional outreach.
It's, and I love everything you just said, and I'm about to bring that in. I did just get a colleague of mine asking if I wanted to speak to one of the media outlets here that wants to do something on the new judges assigned to Charlotte. And I said, absolutely. So I'm going to talk to them, and I want to bring up this case, especially because I think I'm going to research who this Lewandowski is. So I have the correct information of if there's any relationship to Corey. Great person to bring it up is me, because I grew up in New Hampshire, where Corey Lewandowski is allegedly from. The reason I say allegedly is because New Hampshire people are not normally the way Corey Lewandowski is. So it's a very small state of 1 million people, and I know I'll go off on a tangent, but I know a lot of people there growing up because I set a state record there in track, and So now going back.
Wait, hold on. So I want to also tell you one other thing before you go back, if that's okay. So, um, just lost my train of thought on the judges. Have you guys heard about this treasure trove of grievances that former IJs have put together, kind of talking about how there has been political pressure exerted on their decision making? I just learned about this about 2 weeks ago, and I'm really fascinated. I haven't had a chance to find it or look into it, but I'm wondering if you guys have or if you knew about it before.
Was that through NAIJ?
I'm not sure, but that wouldn't surprise me, right?
Yeah, I had seen some posts and some statements from NAIJ, National Association of Immigration Judges, but nothing concrete. More just kind of grumblings onto the pressures that they're experiencing and the workloads and things.
Well, I know that I had raised with you guys the prospects of a lawsuit that would require this government to kind of repatriate, and of course that's not the right word, but return to this country the post-removal deportees. And I think, I mean, I know it's a long shot, but having IJs explicitly state or make affidavits to attest to political pressure, decisions being directed from up on high, that is at a minimum, I mean, at the fringes, the erosion of due process. So I think there is an argument to be made that this judicial independence, which we all know has been a farce for the longest time, is at play, and that political influence is what's directing the course of these outcomes. And I feel like that should have some legitimacy. And Rob, you're the federal litigation guru, but how far do you think that could actually get us when you have IJs, the actual people deciding these cases, saying, you know, I got a memo that morning telling me that this was what the outcome of the case was expected to be? I think that's a smoking gun.
Yeah. Interestingly, there was a district court opinion that I just read earlier today, and I printed it, but I don't know what I did with it.
The one that's going after, is it the one that's yelling at the government?
No. This was a case where the federal judge had ordered a bond hearing. A bond hearing was held. Rather perfunctory bond hearing was held. The the immigration judge found that the person was a flight risk and no bond was in a danger and no bond would satisfy. The respondent's attorney took it back to the federal court and said, "Hey, you know, this was a sham bond hearing," and the court said, "Yes, this was a sham bond hearing. The judge did not look at all the documents, did not look at all the records, and ordered the matter to be reheard." The district court judge even went so far as to say that this was the fifth case that court had seen from the same IJ that had
Rob,
not been looking at the
do you know where
documents.
that's at?
Yeah.
Is it Atlanta?
Yeah, I don't know. I had it somewhere earlier.
I have one pending right now out of Atlanta where the judge wouldn't even let my client testify. And it was one where the Waycross division had actually ordered that they hold a bond hearing, and it was a sham bond hearing. And I'm back in there right now. They basically said, I mean, I tried to ask 2 questions. On the third question, I was told it was such a sham that DHS purposely said irrelevant how they entered. I don't know why it's irrelevant. They had entered on a visa, and I'm just was trying to get to the next step. But it's my I have a right to ask these questions and set up how the person entered, that they came on a visa, they came as a trafficking victim, but they cut me off, and the IJ actually not only shut off the tape, she did shut off the
Star.
the WebEx.
Yeah.
And it's all on the DAR. Like, that's a sham bond hearing. I didn't even get in. Oh, and by the way, she put in the order that my client was convicted of something, and my client was not convicted. It was the charge was dismissed by the prosecutor.
That's crazy. But
we talked about that a while back, and that's one of the things that I've always been litigating in the habeas cases is saying, you know, it's not enough for the judge to just order the court to have a bond. the judge has to order the court to apply the factors and things in the manner in which they've been applied previously. And because otherwise, the things that would get your client bond, length of time in the United States, family connections, employment, all those things now are looked at as detrimental and reasons to not grant bond. It was a Colorado case.
And on this idea that these bond hearings are sham hearings, I feel like we're reaching a threshold of sufficiency. When we have judges granting bond, but at the amounts of 90K or above, I think
That's
that
outrageous.
in and of itself is unconscionable.
Yeah.
Why even bother granting bond at that number? And what does that number justify? If you're saying this person is not a flight risk and is not a danger, but I'm going to grant bond, but I'm granting it at this number that we know is, and it's not going to be, this family can't make it.
It's unconstitutional, if you ask me. I don't think, and I basically today just got an order to basically ordering the court to do what it should have done 3 weeks ago, which is the 11th Circuit had stated that that person was entitled to a bond hearing. And so the DOJ admitted that, and yet they did nothing about it for the last 3 weeks. And it's incumbent upon them. When I wrote to the district court, I'm like, it's not incumbent upon waiting for you to issue the habeas. They already said the 11th Circuit case is controlling. They are supposed to tell their clients to do this bond hearing. Their clients should have done this bond hearing. The responsibility wasn't advocated, while they're waiting for you to issue a decision. They have an ethical and legal obligation to comply. And
Yeah, so much.
so I think, Marium, on your question before, I do think that case will win, the case that you're talking about potentially bringing. And I do think there are lots of immigration judges out there, whether they were released under this administration or they're whistleblowers, the fact that they're facing this political pressure to basically not follow their legal and ethical obligations and have judicial independence is basically a reason to bring everybody back, almost every single person, because they didn't even get, in my opinion, a scintilla of due process, not one scintilla.
We're going to make Sue the chief immigration judge. Okay, I am going to have to jump, but I want to ask you one other thing really quickly, and that is on this case, for example, with the folks that are the Iranian couple. Have you guys had instances where your clients are being approached by USCIS officers during their ICE detention? So I think that my guess would be, if that's happening, that they're trying to elicit inconsistencies that can be used, or maybe try to figure out if these folks have made misrepresentations and they can tack on new charges. But I'm not familiar enough to know, is that par for the course? Have you guys seen that with your own clients? Is that a typical practice? And if you have seen it, is it so that the government can actually levy harsher charges?
It is very typical for, even with represented individuals, for DHS or ICE or any of the agencies to just ignore the fact that the individuals are represented and go in and seek.
You mean very typical today? You don't mean like in all time?
No, I think it's been typical for forever. I mean, I going back years, decades. That's always been very common in the immigration context, and it's always been very problematic. In a case, and especially in a high-profile case like that, I don't think that it's inappropriate, or not to be the double negative there, I apologize, but I think it is appropriate to maybe have to go into federal court to seek injunctive relief to prevent these kind of uncounseled conversations with represented clients. Because it is a significant issue, and it always has been, and I think it's a huge problem.
I think that's why they did that to my client recently. Now that you brought that up, Marium or Rob, whoever said inconsistent statements, they went in on. Remember the guy I just talked about, where I had sham bond hearing. He came in on a tourist visa. He was trafficked at 15. And they went in, DHS, deportation officers went in to question him, knowing he was represented. And I think it was to try to get an inconsistency. And of course, I went through the attorney who's helping me with the habeas and said, hey, can you please let the district court know that they're trying to question my client and he's represented without me present. And of course, all of a sudden, they kind of freaked out. Emily, the deputy, what do they call it? Assistant chief count, the deputy, the management in Atlanta, I don't mind. Emily Reese had wrote back and stated that she apologized for that. Well, she knows better. She knows they're not allowed to speak to them. And then the deportation officer apologized, but I still haven't gotten the statements. What information did you take from my client, and why were you there? And then why is it irrelevant for me to ask this question during the sham bond hearing if you're in there secretly trying to get them to elicit different information?
And Marium, it goes also to some of the state rules too, because different states are going to have different rules with respect to what the ramifications of some of those conversations have, for the client, for the client's case. But ultimately, with the immigration issues being civil, there's not really a suppression mechanism for many of those statements, and there's precious little that you can get done in immigration court. That's why when those kind of events are going on and it is having an impact on the case, there's really very little you can do other than getting some sort of injunctive relief.
There's so much that's going wrong in this particular scenario, though, because as I said, it's a Rubio determination. And basically, DHS did not even authenticate the determination or, offer any kind of supporting evidence for why the judge should accept it at face value. And the judge did. Mm-hmm. That should, in and of itself, trigger a contested removability hearing, because if we're disputing the factual allegations, we don't believe that the determination should be admitted. And if it is, the judge is saying, well, your objections would go to the weight, not to the admissibility. Okay. But the judge kind of just blew right past the idea that when you object to the allegations or you deny them, you're not conceding them, that does not mean that there is a contested removability hearing that is incumbent upon the judge to provide. Instead, the judge can simply decide that the determination made by the Secretary of State is sufficient, and just by offering it, basically DHS has authenticated it. I find that to be mind-blowing. I don't know what evidentiary standard we're holding ourselves to in court, but for a familial association like these two individuals, again, I'm saying no wrongdoing on their part whatsoever other than who they are related to by blood, being the basis of the Secretary of State saying they should be kicked out of our country at a time when we are engaged in an unlawful war on their country of origin. There's so many layers of things that are going wrong here, and there isn't a person of conscience in that courtroom. DHS was entirely silent throughout the hearing, did not even see the face of the attorney. It was the judge doing both the job of the trial attorney and a judge who is being politically persuaded to, again, achieve a preconceived outcome.
They probably picked the judge in my lengthy experience with DHS, and they either picked a very young government attorney who's being forced into that. Just to give you a side note, like going back to a time when Obama's aunt was in proceedings in Boston, they picked my friend, who was the only Black attorney in Boston, and made her do the case. And we talked off the record, and she's like, Sue, I know why they picked me. She goes, I'm going to do my job. I'm going to go in and do my job. There are some issues with this case, like, based on the asylum and stuff. But she goes, it's not passing me why it's not going past me why they picked me. They want me to go in as the only black attorney. They want a black face going against somebody from Kenya, and then it doesn't look like it's racist. And yeah, but and so Rob, sorry.
Well, no, the attorney on the other side of that's an immigration judge now.
What's that?
The attorney that was on the other side of that case is an immigration judge now.
Oh, really? Interesting. Yeah. Well, yeah. And so my friend Helen Moore, who, was assistant chief counsel in Boston, she did not like the fact they put her in that position. And she even mentioned it behind the scenes, saying, not only you did that, also you're doing it to the first African-American president. You're having me go after his aunt. Like, she didn't find that, correct or fair. There are plenty of other government attorneys that could have done that job. And she knew they were doing what they were doing. So I guess my point is too, like they could pick government attorneys that literally either are young or they want to make it look like it's not discriminatory. So they might pick somebody, like say, who's, Muslim to go against somebody who's Muslim. So it doesn't look like that. And then you put this poor trial attorney in this position of where he or she probably doesn't want to show their face either on the camera because it's embarrassing, like what the agency's doing.
I just messaged you guys because I'm going to jump, but Sue, I love your fire. And I said it's like earth, fire, and I guess I'll be water. But Sue, you're fire, obviously. And I'm so glad to see you again. I definitely want to spend some time catching up. I know you've been through
definitely.
So, okay, well, y'all carry on. I think this was a really fun conversation to be a part of. I'll see you the next time. Rob, thanks for putting it together.
See you the next time. And thank you for doing what you're doing with that case, and good luck.
Thank you. Thank you both. Take care. See you later.
Yeah, we'll see you. Yeah.
See you. So I have a few things, Rob, I wanted to bring up as well.
Yeah.
If you have time. So a client of mine asked, and so I was hoping maybe you could shed some light on, there was some kind of Trump executive order or memo or whatever he does.
Yeah.
I don't know what we call these things anymore. His, trying to make new laws on the banking.
Yeah, there was two things. One, there was an executive order, but then, and basically the executive order was just telling banks that they should have a role and look out for fraud in banking with respect to whether people had appropriate employment authorization or appropriate Social Security numbers, that sort of thing. But then it was followed about a week later or so by a policy statement by a group called FinCEN, which is the Financial Crimes Enforcement Network, which is actually just a part of
the Treasury Department, I think.
Yeah. So, but the interesting thing about that is it was pretty clear that they were cooperating with IRS and tracking these things down. They issued I think it was like 16 or 18 point memorandum of things that banks should be looking for. And so what they did was they didn't prohibit banks from accepting ITIN numbers for, opening accounts. But they've strongly insinuated that when ITIN numbers are being used, that they should be looking at all these other things to determine whether or not there's fraudulent employment going on, whether there is other kinds of fraud going on.
Fraudulent employment?
Yeah.
What would be fraudulent about the employment?
Well, an employer hiring people that don't have appropriate work authorization.
Okay, so if they have their own business, then that's not fraudulent.
Well, but if they have their own business, then, whether or not they are appropriately working in the United States. So it really just indicates that to banks that they're going to be targeted if they are allowing these types of activities to go on, or if they're extending credit, business lines of credit.
What does that have to do with somebody just putting money in a bank, which apparently you have to do in this country if you want to pay your bills, because you can't go around and pay cash with everything. They
Yeah.
make you put that in there. The person's properly using an EIN number so they can properly pay their taxes. And so the fact that they're making money, what does that have to do with the bank? The bank is not in the enforcement of the Labor Department.
Well, but the bank has all those records, and it certainly seems like the FinCEN group is going to be looking very closely and expecting banks to report things that they determine to be suspicious, which may mean somebody that doesn't have employment authorization, but they're getting paid or they're earning money. And it's just going to be another way to identify people that are in the United States.
What about all the money laundering that's going on by the billionaires and multimillionaires? I mean, that's what FinCEN's really supposed to be doing.
Well, yeah, but our clients, for the most part, don't own banks. So.
Oh, thank you. Forgot about that.
If you own your own bank, there's lots of different things you can do.
So basically, can they close their accounts, or are they going to just try to steal their money?
I think they would. Who knows what the long term is going to be, but I think it's more of an issue to put pressure on banks to not allow these kind of accounts to exist.
So then the banks won't have any money. The banks need money right now, and they need those depositors, and those depositors have cash, and so they're saying, "To hell with that."
Yeah, well, and I think it's going to create problems for the banks because you don't have to have a U.S. based bank anymore in order to have a bank account and have a credit card and operate. So, I mean, if it drives money offshore into more unregulated banks, more unregulated environments, I think that's going to create a ripple effect that maybe isn't being anticipated. But it's going to create
that sounds like a good idea. Get out of these U.S. banks. Huh?
Yeah, which is interesting because the U.S. banks have been a staple, something that's been looked on as safe and secure and all that. But we may create a impact that reduces that, much like it's reduced in some places the destination of the United States is a destination country for.
Oh, can I tell you what I overheard today in immigration court?
Oh, I can't imagine.
Because you said destination. Oh yeah. Well, I was waiting for this bond hearing that never happened, so I overheard a couple other interesting things. This is public record. None of this is like that I'm going to tell you is not public record. Used to be people could go into immigration courts and watch these proceedings. Right now, everything's online. But this particular, so these two pro se people, one of them was from Finland when you brought up destination. And so she was asking for voluntary departure. She just wanted to go home. She wanted to get out of the southern Louisiana detention center.
We detained somebody from Finland.
Apparently, yes, because, if you make them some type of a criminal, which apparently anything is criminal these days. But in this particular case, I don't know the circumstances of it, but she has a conviction. According to DHS, she had a conviction for misdemeanor theft in Florida. So could have been she stole bread. I don't know. I don't know what she stole. I don't know if it actually really happened, but she had a conviction. And apparently that might be a fact. And the reason I say it might be a fact is when I get to the second case that I overheard, there were no facts. And yet that person got screwed over. So in this particular case, this person from Finland, she wanted voluntary departure. And of course, DHS opposed everything. Voluntary departure, by the way, if you're listening to this and you don't know what it is, taxpayers don't have to pay for the person's flight back. So it actually is a benefit to the taxpayers. Yes, it does give the respondent, the non-citizen, the benefit of being able to return to the country legally, sooner than otherwise, within 3 to 5 years, depending upon the provision of the law. But it's also a benefit to taxpayers. We're not paying for the flight back. So this particular case, it's, pre-conclusion, voluntary departure. There's no CIMT. DHS should have just said no objection. Or I guess they could have stated what they stated, but she ended up getting ordered removed for misdemeanor theft from Finland. And of course she's not appealing it because who wants to stay there in the jail? And the judge could have ruled differently. They shouldn't have to follow what DHS says, but wait till the next case. This is even better. This one really blew my mind. So another person wants to go home, wants to take voluntary departure, pre-conclusion. Forgot what country they're from. I think it was Central America somewhere, but DHS says, we oppose, there's a prior removal order. Well, that's contested by the judge on the record. Judge says, no, there's no prior removal order. There was a prior proceeding that was dismissed. DHS says, well, not according to the I-213. I-213 says that. So according to DHS, that must be fact, right?
Right.
I can't believe under your ethical obligations that you would ever put your bar membership on whatever is stated in I-213. The officer could have made a mistake, or the officer could have purposely put something down incorrect. Either way, why would you ever say, if the court, the one who issues the removal order, the court says there's no in absentia removal order, and this is what he's saying, there's an in absentia removal order. The court is saying, no, there is not. DHS says, yes, there is, because the I-213 says it is. Judge says, okay, DHS, you want to get your files so you can prove it? Yes, we do. Then the judge goes back to the respondent and says, okay, respondent, you want to wait till DHS gets their file to prove this? No, I don't want to wait. And the judge says, okay, and the judge's ultimatum was, you want to wait or do you want to get removed today? Why would you order someone removed who you just stated on the record doesn't have a prior removal, is statutory eligible for voluntary departure? You just stated there isn't one, but you say if you basically want to wait for the file, then for the government to prove something that they just stated that the court is already saying is incorrect, you're going to order the person removed.
Yeah, using detention as a leverage, to take care of people. You know, and the bad thing, well, one of many, but one of the bad things about that situation is, even though that removal order went into effect today, it'll be months before that person is out of detention.
That's what I heard. They don't just get out anymore. It's like months, right?
No, I mean, you know, if you're some of the southern border detention facilities, maybe you get on the next bus, maybe you get on the next plane, but I've
been hearing 90 days. I've been hearing 90 days.
Detained for months after either taking a removal order or asking for voluntary departure and being granted voluntary departure with conditions, because they're detained. So even though you get voluntary departure if you're detained, you don't necessarily get out, and you still have to pay for your travel. But taking months to get out, and so
that part makes no sense, because they probably have, if they want it, they probably have a passport, and they're probably giving the passport.
No, yeah. I've had many clients with, family has the money, the client has the passport, there's travel has been secured, and they're just waiting for DHS to get the travel arrangements together on a DHS approved flight. And who is it? Because
it sounds like they're trying to make extra money off of them. Why aren't they on? I had a client that was put on a flight that I was trying to get not on a flight with a removal order, who was a trafficking victim. They removed him like boom.
Well, and if you're a taxpayer, you should be very concerned. I think that somebody wants to be removed, wants to leave, and the judge orders it or grants the voluntary, whatever it is, and 3 months later they're still sitting there at $100 or whatever it is a day.
Oh, no, it's way more than 100, because it was like 157 back years ago before inflation.
Yeah, so
it could be the price of the Ritz-Carlton a night right now.
Right. So, I mean, you're paying for that. And I don't know how many people are in that situation right now, but just in my small part of the world, it's been quite a few. So,
It's crazy.
yeah.
And I one more thing I wanted to ask you too, because we're talking about it, but I don't know how it's affected you yet. Have you had to do any adjustment of status with those new rules and go in?
I've had to counsel a lot of clients that are very, very afraid, uh, you know, because of it, and some that have been in the process for a long time, and they're just very concerned as to how it's going to play out. And I basically, I've told everybody, it's like, look, it's early days yet. We don't really know how it's going to play out. And I think, from a practice perspective, I mean, I think we just have to be clear with the clients that, look, it's not a given that you're going to be able to adjust status, and maybe, as attorneys, we've been lax on it in the past few years, that not putting into that adjustment package reasons why adjustment is appropriate or necessary. But maybe, it's just something that we're going to have to include in that package moving forward. I think, I suspect it's probably more of just a further way to target some of the issues that we're seeing them target now: the denaturalizations, the fraud, the fraud allegations, the uh, unlawful entries and overstays, and just as a way to make it harder and harder for people to stay and transition into some sort of legal status.
I haven't seen one thing in immigration court where there is one yes. I haven't seen anything over the last year where, I mean, besides a few work authorizations and a few grants here and there, everything is just like everything that is just should be clearly they're eligible for. They're just making completely impossible and difficult, and to the point where it's so mind blowing to me that everything is a no in immigration court. Every BIA decision is a negative. They haven't issued one positive. Um, I mean, it's
Well, and I think we're seeing too a just a push to make everything as difficult as possible, and just to try to force people
to give
to,
up, leave, yeah.
to depart. Yeah. And, I think
Or they're gonna
that's,
have to pay more money because we can't do all of this extra work for free. I mean, unless you want to do it all pro bono, Rob, I'll send them all to you. But I mean, it's a lot, 26 extra questions. That's a lot of extra questions. And, it's unfair to these respondents, but we have to do it because if we want to give them a chance until we can get court orders to say, no, we don't,
yeah.
USCIS is going to require this of us.
Well, and that's a really difficult thing right now, because some of the cases that are just clear
Clearly, grants.
approval type cases, just, your very basic, I met someone and we're getting married, and,
You had a baby.
yeah, and those are
I
taking,
came in legally. I've done everything right.
yeah, and those are taking months and months and months and
I have one
years.
1.5 years.
Yeah, I've got some that have been pending for just way, way too long, and just very simple, legitimate marriage kind of cases, legitimate employment-based cases, just very, 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 very difficult. And
Have
now,
you had to file any habeases on the C9s, the work authorizations not being granted? I have one been pending 1.5 years. He was in status until a month ago. And he's an O1A, one of
mm,
the top ballroom dancers in the world. Even his brother was, and his brother got his lawful permanent residence through it. Unfortunately, he was the better ballroom dancer, but USCIS wouldn't grant
yeah.
his green card under that.
Well,
Um,
there's so many of the detained case, or not detained cases, the work authorization cases that are just languishing.
yeah, and I don't
I,
get that.
I talked to someone today who'd filed their I-751, which is removal of the conditions. When you get married, you get the 2-year conditional green card, and then you can get your 10-year and then citizenship. But had filed the removal of conditions in January of 25.
Hmm.
And this is someone married, family, there's kids. It's
it's a
clear.
real, it's a real thing.
Yeah. So,
I don't get, I don't get it, except that either they're trying to make them where they're working without authorization, again, trying to make things harder, or I do think that 2025, I think they took all those cases, the majority of them, and threw them in a pile, and they're like,
yeah,
there's a whole bunch of them sitting in because I worked for the government before. This is how it works. Like literally, if they just say, okay, you're going to stop doing these, and now you move on to 2026, there's a whole bunch of 2025 cases sitting in different places. Like the Nebraska Service Center has got T visas they've never sent out receipt notices for from 2025. And then the C09s, adjustment of status, from 2025. I-130s that clearly should have been approved within 6 months back in 2025. But 2025 seems to be
yeah. And I haven't filed any mandamus recently, and but it may be the next wave of things that has to be filed. I mean, everybody's been so focused and busy filing habeases because of all the detention and things.
Yeah.
Mandamuses are probably next on the agenda. So
I think that's where I'm going, and I think I'm going to be asking for the equal access to justice fees.
Yeah.
Because I think the district courts, from what I heard today from a friend, and attorney, the district courts they've had it with having to babysit ICE and USCIS, and
depends on your judge, but yeah.
Well, I'm in the South, in the southern. Let's put it this way: South Carolina.
Yeah.
The U.S. attorney in South Carolina is extremely ethical, reasonable, Republican U.S. attorney, and apparently, the district courts too in South Carolina, they've had it. They just had it.
Yeah. And the district courts are all swamped with all the filings as well. So
that's telling your judge, though.
Yeah. All right. Well, Susan, let's call this one an evening and get back together again next week.
Sounds great. Thank you.
All right. Take care.
Bye.